on Unit 7. Unit 7 will go over some of the documents you need to be familiar with that your clients will be receiving at closing. This section starts on page 199 if you're following along in your manuals, and I would encourage you to follow along in your manuals. Two of the documents we're going to be discussing, the note and the mortgage or the deed. You definitely will want to be able to take a detailed look at that in your manual. So let's start with a mortgage note. And we've got an example of a fixed rate mortgage note in your books starting on page 199. So I would encourage you to pause this recording and review that before we go on to the next section, because I will be breaking down and doing a discussion about the different components of the note so we can see everything that's included. But it may be helpful if you're not familiar with this and if you haven't seen a mortgage note before, if you take a few minutes just to review the contents before we discuss it. So if you've taken a few minutes to look it over, you'll see that the note includes a lot of really important information here. The top section of the note contains the date, city, state, and the address of the property securing the note. The note details section is going to include information on what the borrower is promising to repay. The lender is going to be listed here, as the buyer is promising to pay the amount of the loan plus the interest to the lender. And this section is also going to indicate what type of currency is acceptable to the lender. For instance, cash, check, money order. So that'll be identified in the note details section here. The interest rate area should be reviewed very carefully to ensure that this is actually the rate in the program that the client intended. If it's an adjustable rate mortgage, very important information will be listed here showing start dates for the rate, start rates, and also when or if any adjustments will occur. So the interest rate area is definitely something that needs to be reviewed carefully. The payment section contains important information about the payment amount, the due date of the first payment, and the end date of the payments. This section is also going to include any provisions for adjustments or balloons if they apply. The borrower's right to prepay section will state whether or not there are any prepayment penalties. The loan charges section protects the client if the note exceeds acceptable amounts by law. So this is going to protect the client if they are found later to have exceeded what's acceptable and allowable. The failure to pay section will tell you what the lender can do if the borrower does not pay as agreed. If or how much they're allowed to charge in late fees will also be identified in this section. The giving of notices just outlines how the lender will communicate with the borrower and how notices will be delivered. Obligation of persons informs the borrower that all signers are obligated under the terms of this note. So that's called the obligations of persons section. Waivers. This acknowledges that the borrower is waiving their right for presentment and notice of dishonor. So they're verifying that all the information they've provided is accurate. And if it's not, then they are giving up their rights. Uniform secured notes. This section is going to note the times when a note may be due and payable. For instance, the sale of the property, or if you transfer interest to another party. So you're going to see information related to that on that section of the note. Let's go on to a discussion about the mortgage deed. This is listed in your book starting on page 204. So this will be called either the deed or the mortgage. Some states call it different things. So we'll be calling it the mortgage deed for our purposes today. And this is another thing that I do suggest you pause the PowerPoint and look over this document, because as you can see, there's a lot of pages involved. We've got it starting on page 204, going through to page 218. So I'm going to break down all the different sections that are involved, but before I do that, I would tell you to take some time and review it and look over it and then I can do kind of a summary of each of those sections for you. So let's go ahead and move on to a discussion about all the important information contained in the deed or the mortgage. Hopefully you've paused this recording so you could take a look at that document. So let's just kind of break down each section and talk about what it contains. So the first section, the definition section, provides a legal definition of the terms used in the mortgage or the deed. The transfer of rights in the property designates that the mortgage document is the security instrument for the note and for the property. Uniform covenants states that the borrower and the lender have agreed to certain conditions, mainly regarding repayment of the loan. So it's basically the promises that they've both agreed to keep on the borrower side and the lender side. The application of payments describes how the lender will apply the loan payments. Charges and lien means that the borrower is agreeing that liens will not be added to the property without proper notification and approval by the lender. The borrower agrees to maintain adequate insurance on the collateral, so property insurance will be specified here. The borrower also agrees to occupy the property within the agreed upon time frame. So for a residential loan, they'll have to state that they intend to occupy the property within 60 days or 90 days. So that'll be identified here. Preservation and maintenance documents, this really is that the borrower agrees to maintain the property, and it gives the lender the right to do an inspection if necessary. The borrower gives the right to call the note due if the borrower lied on their application. So this is covered in the section on the borrower's loan application, basically saying that full, accurate, and truthful information has been provided. Protection of lender's interest in the property means that the lender has the right to file court proceedings to get their collateral back if the borrower files bankruptcy, abandons the property, or if the loan goes into foreclosure. If mortgage insurance is required on the loan, this section will provide information on it, on the mortgage insurance section. And notices, the notices section will describe acceptable forms of communication between the parties. Governing law simply states that the agreement is subject to local and state laws. Borrower's copy, this section states that the buyer is intended to a copy of the note and mortgage for their records. Transfer of the property. This explains how the borrower may transfer any rights of the property and the penalties if they do not follow the procedures listed. Right to reinstate means that all borrowers will have a reinstatement period if the note is accelerated, and so this section is going to describe that process and give the timeline for the right to reinstate. Because notes are frequently traded or sold, this section will outline the rules of any transfer or sale. So the sale of note will be identified here. Hazardous substances means that the borrower will agree not to store or use hazardous substances on the property. And then, of course, signatures will be collected on the document to make it official. So those are all the sections included, but again, I encourage you to take some time to review that on your own because there is a lot of information included there. Moving on to what should be incorporated if you offer and provide pre-close counseling and if you provide a review of the subsidy closing documents. So if your agency is providing a subsidy or assisting with the subsidy, first, you want to make sure that all the subsidy conditions are met prior to closing. Are they required to verify income? Are they within the income guidelines? Were they required to go to counseling or attend a class? So you'll want to verify that all those conditions have been met. And then also, if your agency is providing the subsidy, be prepared to provide that subsidy payment to the title company. A pre-close counseling session is really highly recommended. It sometimes is optional for borrowers, so it may not be something that's required, but something that's recommended, which is really unfortunate because a lot of valuable information is able to be gone through if you have that pre-close counseling session. Unfortunately, sometimes borrowers get anxious and excited, and they really don't want to take time to meet with you, or they're already taking time off work to go to closing, so it's just kind of additional time off that they need. So sometimes it can be difficult to get them to come in, but it can be really helpful because at that time you can actually go through all the closing documents and you can explain the notes, the deeds, the restrictions, and talk about all the different requirements that have been met. So it can be a really good, especially for first-time homebuyers, which is typically what where you would be doing this type of counseling. It can be really important and help them to have a chance to carefully go through those documents with an expert. So you're going to be there to help guide them through that discussion. This is also when you're going to review that final HUD-1. So you can make sure that, first of all, the subsidy got included if you're providing that, but also that all the information is accurate. So that HUD-1 is going to provide you all the verification pieces that you want to make sure. Here's how much you're borrowing, here's the sales price, here are the fees that have been charged. So that HUD-1 has really all that quite important information that you can review with the client. This is also a time when you can explain not just the contents of the notes and deeds, but also if they have any restrictions or requirements that they have to do prior to closing. So, I mean, by now, hopefully they know if they've had to attend a class or something, but it also can be important prior to the closing if they've got other restrictions they need to know about. For instance, if they have an HOA, you can talk about those restrictions, and just to make sure that they have full information there. If you don't have the actual documents that will be used in closing, you at least can have samples of those documents, and you could even send them home with samples of those documents. And as you go through it, you could highlight the important pieces of information or mark down where they're going to have to sign in those documents. So again, this is really kind of a mock closing that you can walk them through. It'll give them a chance without feeling like they're rushed or kind of under the gun to sign everything, because especially in a title office, they're busy, they've got somebody scheduled right after you. So this is going to give them a chance to read those documents thoroughly, have a chance to ask you questions without feeling like they're running out of time and they can't take the time that they need to carefully review everything. Remind them that they do still want to review the documents prior to signing, because you still want to make sure that they've got all that accurate information and that you review those closing costs prior to actually signing, because you really don't know. Things could potentially have changed. So you still want to remind them that they want to carefully review it again prior to signing everything, just to make sure it's all still the same. Let the client know kind of what's going to happen at closing. Let them know how their money needs to be paid to the title company. Are they allowed to do a personal check? Do they have to have certified funds? Do a little bit of a review on what it means, life as a homeowner. Maintenance. You might have some documents you send home with them about seasonal maintenance checklists and things like that. Really important here is talk to them about what to do if they have trouble. This might be your only chance to get that information across to them. So they, down the road, may have a stumble, and they may have trouble making their payments, and you want to be sure that they don't panic, that they know, oh, that's right, my counselor told me, I need to call the mortgage company, and then I need to call the housing counseling agency. So that way they know it's not the end of the world. Don't panic, don't overreact, but if you do have trouble making payments, here's what you need to do. It's important that the housing counselor is the one who does the pre-close session, because again, you've built trust with them. You're the one who's going to be trained on those documents. So it's important that you have a certified housing counselor doing that pre-close session. You may also, if you're fortunate enough at your agency to have an attorney who knows about subsidies, You may also have them involved, and some states may require it. So you'll know your particular state requirements, but it would be helpful if you could have an attorney involved at this stage if you have that capacity. So this concludes Unit 7 in your manual.